Hello everyone, welcome to the channel No Spear. This is Sheshadri Kulkarni. In this video we are going to know about High Courts of India, their powers and functions. The High Courts of India are the highest courts of appellate jurisdiction in each state and union territory of India. After Supreme Court of India, it is regarded as the country's second highest court. In India, there are currently 25 high courts located throughout the country. In the Indian scheme of judicial system, high courts work below the Supreme Court. The judiciary in the state consists of high court and hierarchy of subordinate courts. History and background of high court. It was in 1858 when, on the recommendation of the Law Commission, the Parliament passed the Indian High Courts Act 1861, which suggested the establishment of high courts in Calcutta, Madras and Bombay by abolishing Supreme Courts and Sadar Adalats. The high courts in these presidencies were established in 1862. The Calcutta High Court is oldest and first high court in the country, established on 2nd July 1862. These high courts had the distinction of being the highest courts for all the cases till the creation of Federal Court of India under the Government of India Act 1935. After the formation of the Constitution, India follows a single integrated judicial system, which means that the apex court, that is the Supreme Court, is the head of all the courts and the high courts of all states function under it. High courts are the highest judicial body at the state level, and the territorial jurisdiction of the high court is proximate to the territory of state. There are 25 high courts in India, 6 having control over more than one state or union territory. Composition of High Court. The judiciary in the state consists of High Court and hierarchy of subordinate courts. The Constitution of India provides a High Court for each state. However, the Parliament is authorized to declare a common High Court for 2 or more states. The territorial jurisdiction of a high court is coterminous with the territory of a state. Furthermore, the Parliament has been empowered to extend or curtail the jurisdiction of a high court over a union territory. Article 214 says that there shall be a high court for each state of the Indian Union. It is the highest court at state level. As we know, the Constitution of India provided for single integrated judicial system for the whole country. So, courts in India administer both the central laws as well as state laws. Article 215 states that every high court shall be a court of record. The judgment, proceeding and act of high court are recorded for perpetual memory, testimony, and it has all the powers of such court, including the power to punish for contempt of the court. Article 216 states that every high court shall consist of a chief justice and such other judges as the president may from time to time deem fit and necessary to appoint. Means the judges of high court are appointed by the President of India. The Chief Justice of High Court is appointed after consultation with the Chief Justice of India and the Governor of the state concerned. Powers and functions of High Court. Powers and functions of High Court are as follows. Original jurisdiction. The High Courts enjoys the same powers which they enjoyed ever since the commencement of the Constitution. Before the commencement of the Constitution, High Courts enjoyed original and appellate jurisdictions. The new Constitution has not withdrawn their rights. Every High Court has original jurisdiction in regard to admiralty, will, divorce, marriage laws, company laws, etc. Cases concerned to such matters, including contempt of court, are directly taken to High Court. Appellate jurisdiction. High courts are also the highest of appeal in any state. All the high courts have appellate jurisdiction in all types of cases against the judgment of lower courts. If a session judge awards death sentence, an appeal can be made to high courts against such judgments. In civil cases, an appeal can be made to High Court against the decision of district courts. High Court is a court of record. The judgments of high courts are considered as authoritative and serve as the basis for future judgments. They are published and referred by the pleaders in the lower courts. Power of supervision. Every high court has the power of supervising over all the courts throughout the territory of the state. It will see that all lower courts discharge their duties properly. Power of interpretation of Constitution. High courts can withdraw a case pending before subordinate court and may itself dispose of the case or determine the question of law involved in the case and return the case with its judgment on the question to the court for disposal. Power to issue writs. Like Supreme Court of India, every high court has been given power to issue writ for the enforcement of fundamental rights and other purposes. It can issue writs in the nature of habeas corpus, mandamus prohibition, etc. Administrative functions. Since high courts stand the highest in the judicial system in a state, it supervises working of lower courts, frame rules and regulations for the administration of justice. They can also examine records of lower courts. They may issue general rules and practice of courts. They may prescribe rules for maintenance of accounts, etc. So friends, this was about the High Courts of India, their powers and functions. Hope you loved this. Do like, share and subscribe the channel NoSpear for more such interesting informative videos. Thank you.